Hey, thank you all so much for being on time. Back right at 1:15, fantastic. So now it's time for our second panel, which is entitled Accountability and Repair, Defining Justice for the Crime of Ecocide. And it's going to be chaired by my Promise Institute colleague, Zhang. So I'll hand it over to you, Xuchen.
Thanks, Amanda. Good afternoon, everyone. Welcome to the second panel of the day. As Amanda said, I work at the Panellists Institute for Human Rights in its Europe location. I'll be chairing this panel today. We'll be examining specific elements within the definition of ecocide, which feels like a very much needed discussion based on just the last panel. And we will be mostly referencing to the IEP proposed definition, but we will be also looking at other legal frameworks related to environmental harm. This panel is divided by theme into 4 parts, so we'll be bouncing back and forth between different panelists a little bit. I hope we will pull that off. Thank you to all the panelists who allowed me to divide up your papers. Just to note, as I've told all of you before, you are free to comment and offer responses to other people's presentations. And before we go into the introductions of the panelists, I just want to give you an overview of the 4 parts of the panel. The first would be focusing on the severe and widespread or long-term environmental harm element. The second would be the wanton or unlawful act element. The third one is mens rea. And the fourth one is actually what the definition doesn't cover, which is how do we sentence or punish ecocide or offer legal remedies. Now, please allow me to introduce our panelists. I apologize in advance that in the interest of time, I would not be presenting their full career paths. All amazing, but I do apologize. I am sure their expertise and insight would be reflected through the discussions. So to my immediate left is Professor Gregory Gordon. He is a professor of law at Peking University School of Transnational Law. He has previously worked at the ICTR in the U.S. Department of Justice and also trained prosecutors in Ethiopia, Bosnia and Herzegovina, and Cambodia. To Gregory's left is Catherine Savard. She is a PhD in law candidate at the University of Oxford, where her thesis focuses on ecocide in environmental law specifically. Catherine has clerked at the Supreme Court of Canada, advised the National Inquiry into Missing and Murdered Indigenous Women, and coordinated the Canadian Partnership for International Justice. Next up, we have Lisa Oldring. She is an international human rights lawyer with 20 years of experience working at the UN and other international organizations. She is currently a PhD researcher at the University of Amsterdam Faculty of Law and a senior fellow at the Promise Institute in its Europe location. Finally, we have Hector Herrera. He is an environmental lawyer with a master's in public policy from the National University of Colombia and a PhD in development studies from the University of Antwerp, Belgium. I will not be talking more about the specific papers and leave the details to them. And also, I'm sure from the agenda, you could already tell they're very self-explanatory titles. So without further ado, I will jump right into the first element we're going to discuss, the assessment of harm. And if I may, Lisa, to start with you on how your paper discusses the application of this aspect of the definition of ecocide to the Alberta oil sands operations.
Okay. Thank you, Xuchen. So maybe to start with a big thank you to the organizers, because this morning's was fascinating and really, I think, laid some good groundwork for our discussion this afternoon. Also to say what I'm presenting is a paper co-written by Kate McIntosh and I, building on sort of the notion that the environmental destruction in the Alberta oil sands region could amount to ecocide. And this is something that's been long referred to as ecocide. It's a context that's been referred to as ecocide by affected communities, in the media, in the scholarship. Damien Short has done fascinating work on sort of seeing this as a slow industrial genocide. And so our article kind of takes this work forward, but looks specifically through the lens of the international proposal, so the definition that is the focus of discussion today. We grounded our work in publicly available data, and we benefited from a really rich body of research, particularly by Indigenous researchers, scientists, environmental organizations, and others. So maybe just very briefly for context, the industrial extractive operations in the Alberta oil sands cover a huge area of northern boreal forests. And these are sometimes referred to as the Amazon of the North. It's roughly the size of Greece or Nepal. So it's a very large geographic area that is covered. It represents the 4th largest oil reserve. And while the operations are privately owned and operated by various different companies, they're a major economic driver for the province of Alberta and across Canada, across the country. The operations began in the late 1960s and they continue to expand today. So just for an example, the output of oil sands raw bitumen this year has averaged a record-breaking 3.5 million barrels per day, and the production continues to expand. More context, the operations have caused significant deforestation, destruction of peatlands, but they've also created a huge amount of wastewater tailings. So the byproduct of the process, the extractive process, has resulted in what they call tailings ponds, which are actually massive lakes that now amount to about 1.3 trillion liters stored in huge toxic lakes across the region. These and other parts of the extractive processes cause air and soil pollution, and they also require an immense amount of water to operate the extraction. The harms are compounded, obviously, by the significant greenhouse gas emissions that are fueling global climate disruption. Very importantly, the extractive operations are located on the traditional territory of many First Nations and Métis communities in Alberta. And they're home currently to approximately 23,000 Indigenous peoples from 18 First Nations and 6 Métis settlements. So this land is subject to treaties that date back to the late 1800s between the Crown and Indigenous peoples in Canada. And I think it's just an important context to set because it really can't separate the extractive operations and the harm that's being done from the colonial history and the extractive economy in Canada. So our article really addresses the historic but also ongoing destruction that comes out of these operations. And for today's discussion, I just wanted to highlight the challenges or some of the issues that came up. So I don't want to present conclusive findings, but we came across a number of issues. So the first is maybe an obvious one, but it's to look at who or what is harmed. When we look at the definition, it doesn't require human harm to be threatened or established for ecocide to take place, but it allows human harm to be considered along with non-human harm in considering the severity of the harm. When we look at the description of the prohibited damage, it doesn't separate humans from the rest of nature, and this is an important perspective that we looked at in considering the harm. So in this sense, it's an ecocentric definition, seeing people as interconnected with the rest of nature. And so in applying this approach, we looked at all elements of the environment, from microorganisms to human beings and all things in between, including clearly harm to the Indigenous peoples in the communities on which the operations are taking place. And so I wanted to come back to something that Felix said this morning, because I thought there was a really brilliant comment that he made about questions of harm, not only as damage, but also as rupture in sacred relationships. And this would certainly apply, I think, in the Alberta oil sands context. Secondly, it raised important questions related to the factual basis on which we looked at for our assessment. And two issues that emerged in this regard: the data is largely reliant on industry self-reporting. So this in itself brings challenges, obviously. And there's also a lack of focus on cumulative impacts. So it's difficult to gather the relevant information for the purposes of the definition of ecocide without having a full look at the cumulative impacts of the harm. And in this regard, I think the lack of investment in addressing Indigenous peoples' concerns that they continue to voice in relation to harm to their health, so a significant number or higher rates than usual of rare cancers, serious mental health issues, and so on, that have not been assessed, and that makes it challenging again to assess the severity and long-term nature of the harm. A third question relates to the timeline for assessing harm. So again, these are operations that date back to the 1960s and continue to take place. And so with historic, cumulative, and ongoing harm, with different oil sands companies responsible for different aspects of the operations, there are challenges there in terms of timeline. Against what timeline should the harm be addressed? And this is also important because of the definition looks at ecocide as a crime of endangerment. So it requires not just an assessment of the harm that's already done, but the risk of ongoing and future harm. So I think the timeline is an important question. And related to this, what is the reach that should be considered when we consider severity of the harm? So for example, the deforestation that takes place obviously causes loss of biodiversity, peatland and vegetation with related compound effects for wildlife and so on. But there are also issues around the fragmentation of land and the impacts this has on wildlife, but also cultural disconnection for indigenous peoples in the region. And so I think the assessment of severity needs to account for this full scope of the disruption. And finally, assessing alternatively to the widespread nature, whether the harm is long-term. This raises questions of whether harm can be reversed through either natural recovery within a reasonable period of time. And so in the Alberta oil sands, there were issues around remediation and reclamation, and questions, can this ever reverse severe and widespread harm? So for example, mine operators by law are required to return the land. The language in the legislation is to an equivalent land capability, but this is a really vague term that's interpreted variably, and the regime basically for enforcing this is criticized as lacking in accountability enforcement. And to date, only about 0.1% of land is certified as reclaimed. And that's partly because the operations are ongoing, but it's partly also because of these issues with the regime. And finally, maybe just to highlight in relation to long-term, the cultural perspectives that are so fundamental to the consideration of harm in this context. And Indigenous researchers have highlighted that for many Indigenous peoples, once the land is harmed by these extractive practices, it's changed forever. It's no longer the same place. It has lost its spirit. The landscapes are not just land, they're repositories of stories, they're places for cultural traditions, lessons, they're sources of medicinal plants, and so on. And so even with the promise of remediation, there are really serious questions, I think, that need to be addressed in relation to the knowledge, spirit, and culture of land that cannot be replaced. So those were some of the considerations that we came across.
Thank you very much, Lisa. Yeah, so I mean, these terms for the threshold of harm are not exactly novel or unique to ecocide, the definition of ecocide. But yeah, as we can see, interesting questions begin to surface once you try to apply it to a real life situation, even if hypothetically. But we have a real application already with Colombia's special jurisdiction for peace. So Hector, please tell us a bit more about that process.
Thank you, and thank you to the organizers. It's been very interesting. This is based on the article that we wrote with my colleague, Juliana Galindo. Unfortunately, couldn't come. And basically what we did is we saw the experience in Colombia with transitional. And we saw how the special jurisdiction for peace created for this transitional justice declared environmental war crimes. And then in the declaration of an environmental war crime, it has the three elements. So then, and when we saw the definition, we compare it with the definition of ecocide, we find that it has the three elements that the tribunal, the special jurisdiction for peace, used in this declaration, in this formal charge of the environmental war crime. So that's basically our approach, and then we bring some lessons from that, like real life experience. So maybe a little of context for those of you that are not familiar with this. In 2016, the FARC-EP guerrilla had a peace agreement with the Colombian government. And as a result of that peace agreement, they created a special jurisdiction for peace to prosecute to judge those crimes that don't fall under amnesty. Then this tribunal has processed some of these crimes, and they had 11 cases, or macro cases, because this is like a massive amount of crimes perpetrated over 50 years of armed conflict. In these 11 cases, we focus in case number 2 and number 5, which both happen in the southwest of Colombia. And this is important because this is like in the southwest corner of Colombia, and then you have like to the south, you have Ecuador, like the east you have the Amazon, or actually overlaps with the Amazon ecosystem, but also you have the Pacific coast, you also have mountains, so you had a very important biodiversity and very important like encounter of ecosystems. And then in this context, the actions of the FARC-EP guerrilla happen, and they cause this environmental harm, environmental damage. Actions such as mining, actions such as land mine deployment, also, and very important for our analysis, attacks against pipelines, oil pipelines with bombs, which cause oil spills, which cause severe, you know, the first element, severe, and then widespread, second element, and then long term. Then in the assessment that the tribunal does, they classify these actions as environmental war crimes that fall under their jurisdiction because they cannot be under amnesty. And interestingly, they base this assessment not only in scientific, technical information, but also in intercultural expertise. So in this area, or where these cases are located, you have the presence of the territories of indigenous communities, Afro-Colombian communities, and also campesino farmers communities. And then the tribunal also asked the authorities of the traditional authorities of indigenous Afro-Colombians, what was the impact, for example, of the attacks on the pipelines, and they take into consideration in the assessment of the harm, of the environmental harm, this. So that's also a very important lesson, this intercultural epistemology, not only like the usual scientific assessment, but also intercultural epistemology. Also, well, another interesting, important lesson from this experience of these two cases is that they had a relational, ecocentric understanding of justice. And this is a mandate from the peace agreement. It needs to be territorial, environmental approach to of justice. And then they acknowledge in the assessment in the tribunal that it's not only like anthropocentric, but also they try to reach to this environmental, relational understanding of justice, which is complicated, and we go into those details in the article. And also, I would say like it's very interesting to see how in practice they put together the three elements. This triad was severe, widespread, and long-term in declaring environmental war crimes in the situation of Colombia, and how this and the lessons from this can be applied to the eventual prosecution of ecocide, and especially this very important lesson of the intercultural expertise being taken into consideration.
Very valuable lessons from an already existing mechanism. Any immediate responses, comments from our other two panelists, please feel free to.
I think there's a lot of dovetailing that when I do my presentation on sentencing, it's clear. I mean, the oil sands it's a case example set in Colombia. about the many challenges of what you have to do in the aftermath. So I'm looking forward to engaging with that in this context. Yep.
Yeah, it's coming up, people. All right. So we've looked at the assessment of harm, and now I guess we can move on to what causes the harm, right? So that would be the wanton or unlawful act element in the definition. And again, sorry, Lisa, I'm going to start with you because your article does specifically talk about this, and you have some very interesting reflections that also relates to our previous panel and the next panel too. So yes, please go ahead.
Well, thank you. This was a very interesting part of the paper for me because there's so much focus, I think, on wanton in the scholarship especially, and there's less, I think, focus on unlawful. And we address both of these elements, but maybe to just speak to unlawful first. The definition doesn't detail what is meant by unlawful or specify what legal framework against which this should be measured. The commentary from the independent expert panel explains that this was deliberately left open so that it might address both national and international law. And this opens layers for consideration, and we kind of took advantage of that and dove in our analysis and looked at various different avenues. So firstly, we looked at allegations that the oil sands operations contravene various different domestic environmental regulations, as well as challenges by affected indigenous communities that there are, that the damage caused by the operations contravenes treaties between the Crown and indigenous peoples. So that was sort of one area that we explored. The second was that we looked at suggestions that domestic regulation and oversight has basically been ceded to industry. Allegations there range from ineffectiveness and excessive regulatory discretion to full corporate capture. This is a term that kept coming up. The notion that the domestic regulation has been taken over by industry interests such that it is no longer effective. And the specific failure of the provincial regulator to gather credible and relevant environmental data was an issue, to conduct routine on-site inspections, and to protect ecosystems from harm is highlighted as inconsistent with its regulatory responsibilities, and again, flagged as an indication of corporate capture. Then we looked at allegations that much of the operations, the harm that's results from the operations violates Canada's obligations under international human rights law. And this is maybe not an area that is always addressed, but First Nations have for many years brought their concerns over human rights violations attributed to the oil sands operations, including as recent as this year in a number of ways. First Nations have brought their concerns to the attention of UN special procedures, for example, highlighting complaints ranging from ongoing land and habitat destruction to air and water pollution, to also the disproportionate impacts of climate change that they experience as a result of the operations. Indigenous groups have criticized the government for also failing to respect the right to free, prior, and informed consent, which is both an international human rights law obligation and an obligation under Canadian law. Also the obligation to adequately regulate the industry by setting and enforcing science-based but also culturally relevant regulations, and to manage cumulative impacts that I mentioned before, as well as to ensure the effectiveness of reclamation processes. And finally, we looked at questions related to Canada's international law obligations in relation to climate change. And this relates to scope 1, 2, and 3 emissions connected with the oil sands operations. And I think these considerations take on a sort of renewed focus and vigor following the ICJ advisory opinion on the obligations of states in relation to climate change. So in other words, there are multiple ways that the oil sands operations could be viewed as unlawful, or multiple lenses through which this issue can be addressed. But we sort of concluded that international law provides a really essential guardrail, particularly in contexts like this one, where there are credible allegations of corporate capture of the domestic regulator. Some of these might apply to the operations as a whole, but others apply to only one aspect or only one area of this very vast extractive operation. And so the question of whether unlawfulness in one area is sufficient to bring the whole enterprise within the definition of ecocide is an important one, and whether a kind of a pattern of illegality over multiple different legal frameworks could potentially meet the unlawfulness test is also, I think, an important question. We then looked at the alternative criteria of wanton. So in other words, whether harm is clearly excessive in relation to the social and economic benefits it brings. This raises really important questions of how social and economic benefits are defined and then how they're assessed. So for instance, the oil sands obviously provide income and employment for thousands of people, both in Alberta and more broadly in Canada, including some Indigenous peoples in the area. Royalties that are paid by the oil sands operators to the government is a really critical source of revenue for the government, which then pays for a range of essential services. And a lot of the oil that eventually results from the oil sands is exported, and that brings considerable revenue as well. So if we look as a whole, the industry contributes in important ways to the economy of the province and the country, but also corporate benefits are staggering. Looking at the 6 largest oil sands company, their annual profits reportedly are in the range of about $35 billion. So they're very significant economic interests in relation to the oil sands. But of course, the economic benefits don't account for climate change disruption or elevated insurance costs, health costs, and so on. In addition, if you juxtapose the economic considerations with the severity and widespread long-term nature of the harm, there are important questions of distribution and justice. So, for example, who enjoys the benefits? Are they the same communities that experience the burdens of the harm? And to what extent are the benefits equitably shared across different social groups? Secondly, over what spatial range should those questions be measured, so social and economic benefits, and is this coextensive with the area in which the harms occur? So in other words, can severe widespread harm to the environment in one area escape the classification of ecocide if it benefits people that are far away from the damage? And should benefits of harm be weighed affect the same communities? Or, can harms inflicted on one segment of the society legitimately be offset by benefits conferred upon others? I think that would not be the intention of the definition. So there are important questions there. And in this regard, we highlight one specific issue, which is, if you look at the Rome Statute under Article 21.3, this requires, there's a really important interpretive tool enshrined there that requires the application of the law. So if ecocide is a crime under the Rome Statute, the application of this law needs to be applied in line with internationally recognized human rights. And this would include, for example, the right to a healthy environment, particularly, again, after the various advisory opinions that we've just been following the last few months. Maybe a final consideration arises regarding the baseline against which you measure benefits. So again, considering that these are operations that have existed for over 50 years, should the evaluation of social and economic benefit be conducted relative to a time when the oil sands operations never existed, or in which they've ceased to exist, or against a time where they've transitioned into a renewable energy framework? Should claims of social and economic benefits be scrutinized not just for how they're distributed, but for how they compare to plausible alternative pathways that minimize harm? So there are some really interesting modeling exercises that have been done that point to the significant benefits of reduced oil sands extraction that would immediately reduce greenhouse gas emissions, air pollution, and freshwater use, obviously, resulting in widespread benefits for human health, ecosystem integrity, and climate change. So in other words, the implementation of the wanton test, I think there's a lot in there that can be unpacked, that needs to be considered, whether the benefits outweigh harms, not only whether benefits outweigh harms, but whose interests are served, whose well-being is compromised, and what other paths could offer greater equity and environmental well-being, I think, in the longer term. So those are issues that we looked at.
Oh, very thought-provoking, truly. Reactions? Or, I mean, we could also wait till the Q&A, where I'm sure people would have a lot of thoughts on this topic as well.
I think my presentation will dwell on what you're saying quite a bit, and I will have questions later as well.
Wonderful, yes. I was thinking the same, because mens rea is clearly very closely related to conduct itself.
And the tar sand extraction is such a paradigmatic example, so I use it often as well.
Yes, I mean, just hand it to you. Like, we're ready to start. Yes. And I know you have a presentation.
I had a to show definitions.
Yeah.
So my paper focuses on the mental element of ecocide, and specifically if ecocide was included in the Rome Statute. So in conclusion, I will discuss a little bit like domestic prohibitions. I know I often have questions about that as well, and some people in the room will be interested also, but I wanted to insist the focus is very much in the Rome Statute. And something that I find fascinating is that we have 50 years of definitions of ecocide since the 1970s up until today. And in this half a century, pretty much every possible mental element was suggested for the definition of ecocide. So the first draft convention on ecocide in 1973 included a specific intent to disrupt or destroy a human ecosystem, which is extremely stringent. It's based on the definition, and it's inspired by the definition of genocide. A few years later, others suggested strict liability, which is the absence of mental element, and the expert panel suggested something in between in this definition, which you all know, but still. So they suggested this standard, like the knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment. So something that I found interesting as well, and that's the starting point of my research, is how the expert panel justifies this definition. So this is pretty much everything that the commentary says on this topic. So this is the mens rea of recklessness or dolus eventualis. There is a rule in the Rome Statute, Article 30, which provides for a default rule on mens rea. This rule is too narrow, therefore we propose recklessness, dolus eventualis, because it is sufficiently onerous to ensure that at the end that only those persons with significant culpability for grave damage to the environment will be held responsible. So that's quite short. Like, there are other alternatives between specific intent and strict liability, so I wanted to explore that, and possibly to find alternatives should states reject the standard or continue the conversation on the topic. So how do we go about that then? How should we think about the mental elements of ecocide in the Rome Statute? Well, in my view, this is a balancing exercise pretty much. So we need to strike the appropriate balance between, on the one hand, over-criminalization and having a very broad definition or a very low mental standard, which would be at odds possibly with the Rome Statute, with the International Criminal Court's mandate. So the ICC is very much focused on the worst acts of concern to the international community as a whole, so the definition needs to reflect that and to be stringent enough. But on the other hand, we also want a definition that would be practicable and that can actually be used to lead to prosecutions for acts such as tar sand extraction or others. So we need to strike the balance between over-criminalization and effectiveness. So I started with this inquiry by looking at the Rome Statute itself, looking at the general rule on mens rea, how that relates to ecocide. And this has been interpreted, this general rule has been interpreted to include both direct and indirect intent. So that's the starting point. And I will argue that we need to derogate from this general rule. So looking into the Rome Statute framework, what other mental elements exist? There is recklessness, but there is also negligence and willful blindness. So I'm discussing these in the context of the definition of ecocide. So direct intent is pretty straightforward. I'm going to go quickly on this. So it exists when the individual wills to attain a certain result. So if I want to cause someone's death, I poison their drink, I act with direct intent to, in relation to their death. In the context of ecocide, so for every standard, I tweaked the independent expert panel definition to see what that could look like. So that would be acts perpetrated to cause prohibited environmental damage. But the problem here is that human beings very rarely intend to destroy or harm the environment. If we think of tar sand, for example, like actors are driven by capitalist ideals, by their relentless pursuit of resources, and environmental damage is often seen as a corollary. It's not what is intended, but resource extraction is. So this wouldn't necessarily fit direct intent, and so this would not be a practicable standard. So I'm going to go quickly on this, but it's not extremely controversial. And direct intent is more interesting, or more more interesting, let's say. So this exists if, for example, I want to bring about someone's death and I poison the meal that they share with someone else. So I know with practical certainty that this other person will die as well. So that's the criteria. So I know with virtual certainty that the prohibited consequence will occur. So in the context of ecocide, it will look like this. So knowledge that they would cause the prohibited consequence. So this can appear promising at first, and this is actually the solution that was adopted by Belgium in their domestic law utilizing ecocide. The issue with that is that in many cases it will be difficult to prove with virtual certainty that the perpetrator knew that the prohibited consequence would occur with virtual certainty. And this is especially true in the context of large-scale projects carried out over large portions of territory spanning decades, and especially when, as we were mentioning earlier, corporations, for example, can be self-reporting, and this can provide a skewed picture of the impacts. So it can be very hard to prove with the knowledge that the consequence would follow with virtual certainty. So again, I'm mindful of time, but I would argue that we need to derogate from this general rule. We have these three options. Negligence is the lowest mental requirement present in the Rome Statute. This is where the perpetrator should have known that the consequence would occur, but failed to acquire that knowledge. For example, the war crime of conscripting children soldiers, the elements of Pratt mentioned that the perpetrator either knew that the person was under 15 or should have known. So if they fail to acquire that knowledge, then this falls under this mental element of negligence. So in the context of ecocide, the perpetrator knew or should have known. That's the classic formulation of this. So this can be very promising in a way because, well, this is the most environmentally protective standard. It's the lowest mental element that we can find in the Rome Statute. So it would criminalize, for example, failure to conduct thorough environmental assessment or conduct or similar conduct. However, international criminal law has traditionally been very reluctant to criminalize this failure to acquire knowledge. It's very rare also in the Rome Statute framework. And it can be criticized. Some will consider that it opens the door to over-criminalization also because it encompasses a very broad variety of conduct, including conduct that possibly doesn't warrant the stigma associated with an international condemnation. So I'm a bit wary of that standard for that reason. Recklessness now. Recklessness is more similar to indirect intent, and that the perpetrator is aware that there is a prohibited consequence that might occur, but we don't have to establish this knowledge like with virtual certainty. Like the perpetrator doesn't have to be virtually certain that the prohibited consequence will occur. We need to prove that the individual is aware of a likelihood that this consequence will occur. So that's the independent panel definition that we know. So it's not knowledge of any likelihood, which could be like a remote possibility of environmental damage. It's knowledge of a substantial likelihood. So the bar is a bit higher. Like we're not talking about any likelihood, but it needs to be a substantial likelihood. So in my view, I do think it's a very helpful middle ground between criminalizing negligence compared to direct or indirect intent. I think it strikes a really interesting balance between these two. It ensures that it's not over-inclusive in a way, but also it ensures that it strictly includes acts that warrant the stigma associated with an international condemnation. I'm full of time, so I'm going to go a bit quick on this, but I'm happy to discuss this further as well. Yeah. And the last standard, willful blindness. There isn't a lot of jurisprudence from the ICC on this standard, but it is extremely narrow in scope. It is limited to cases where we can almost say that the defendant actually knew, but turned a blind eye and failed to conduct appropriate inquiry. I'm trying to go a bit faster about this, but this is what it would look like in the context of ecocide. It is a helpful middle ground, in my view, between criminalizing negligence and actual knowledge, but it is still very limited in scope to certain very limited situations. There is not a lot of jurisprudence about it in the context of the Rome Statute, so we can question whether this would, and it has not been discussed a lot also in the literature surrounding ecocide, so we can question whether states would eventually accept this standard or not. So in my view, this is the next best thing after recklessness, but recklessness still remains the most readily applicable and acceptable standard. So in conclusion, to wrap up, I really think that when it comes to the mental element of ecocide, I do think the independent panel definition offers a fantastic framework. And it strikes that balance between over-criminalization and effectiveness. But again, I want to come back to something I said at the beginning. This research is very much anchored in the Rome Statute framework, and domestic initiatives do not necessarily operate under the same considerations. I want to draw attention on the manual for the criminalization of ecocide that I published earlier this year, which really addresses these issues specifically. It is also argued there that direct and indirect intent are too restrictive and that recklessness can align, for example, with the European Crime Directive and can also offer a helpful standard. All this to say that what I'm saying here can be taken with a grain of salt in the context of the domestic prohibitions because different consideration will come into play, but still, in many cases, recklessness will be a helpful standard in the domestic prohibitions as well. That's it from me for now. I hope I'm not too... Thank you.
Because we do have like a real life scenario, right, with the Colombia's pronouncing it right. So yeah, like I think it has some interesting experience with assessing the perpetrator's mental state. So Hector, please.
And that was a very important question, as the assessment of the prosecution of the environmental war crimes perpetrated by the FARC-EP guerrilla. The question is like, they are judging the commanders of the guerrilla. So it was not like the actual guerrilla soldiers that perpetrated this bombing in pipelines that cause oil spill and environmental damage. Then the question was like, all of this, like, well, are these commanders responsible? Many times they didn't did the actual action. So what they did in the tribunal, they used two variables. The first one is command responsibility, and and this is also very important in the special jurisdiction for peace in this transitional justice of Colombia. Since it's transitional, they have like this special option of using a wider legal sources, so they can base their judgment on in international criminal law, also in international law, human rights, humanitarian law. So they they use several sources, and you see in the arguing for declaring the mental element of the guerrilla commanders on this. And then they use this first element of common responsibility, and the second one is indirect co-perpetration. So they say they were aware that these actions, I'm focusing on this one, but there are others, of bombing petroleum infrastructure. They had awareness that this will cause ecological damage and also community damage, and also they infer this from three elements that is included in the prosecution. Is when there was a systematic acts prolonged for over time. So there are hundreds of attacks against the petroleum infrastructure. So this is systematic, and over time, over 20 plus years, this was a strategy of the guerrilla to attack the Colombian state. Because attacking the petroleum infrastructure, they will hurting the economy of the state, and so it was systematic and over time. And also testimonies of former combatants that they said well, we knew there was environmental impact. So that was also taken into consideration. And also the absence of preventive measures. So they knew there was this environmental damage, but there was no any effort to reduce this damage. And then finally, a reflection that's also in the prosecution of these actions is signaled by the Special Jurisdiction for Peace, is that this overlap of these three dynamics of economic gain and military strategy and environmental destructions. How you need to look at the bigger picture to understand what was happening. In this case, the guerrilla using as a strategy attacking the petroleum infrastructure to damage the state, but causing environmental harm, severe, widespread, long-term environmental harm that can be classified as environmental war crime. Also matches the Ecocide definition.
Very useful indicators for everybody to consider in the future, I suppose.
This is a paper that I did with my former PhD student, Daley Burkett, who's now an associate professor at Birmingham Law. And we focused on the ICC, and this is part of a larger project that we're doing on sentencing in international criminal law. So we also have a paper that we're doing right now on sentencing aggression. And so there are a lot of very interesting overlapping issues. But I think there are a lot of very interesting issues related to ecocide that made this a very, how should I put it, a very rewarding paper to work on. And what we realized was that at the domestic level, leniency in sentencing for serious environmental crimes was the norm. And we just looked at a long list of horrible crimes: Exxon Valdez, Deepwater Horizon, the 1984 Bhopal gas disaster. And the executives at the companies who were responsible for this either got no incarceration or just slaps on the wrist. And the question for us was, can international criminal law do better? We focused on the IEP definition. And again, you've heard it many times here, but just for purposes of this paper, unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. I just want to make sure that my comments today are framed in terms of that definition. And I believe that this inquiry about whether ICL can do better is pertinent, especially now, because the IEP definition is under serious consideration for incorporation into the Rome Statute, and there's been little to no scholarship on the issue of sentencing. So our paper is the first to directly engage with this inquiry. The way I want to approach it is looking at, and I have, in the paper it says brief history of punishment in ICL. Here I've added very brief. I'm going to be extremely brief here. I want to look at the ICC sentencing schema, and then the two most important concepts out of this Both relate to gravity. So I'll explain this, but in abstracto gravity and in concreto gravity, and then I have some concluding thoughts. First, that very brief history. The post-World War II tribunals, Nuremberg, Tokyo, of course, handed down crucial precedents for international criminal law prosecution, but left what we argue is a theoretical vacuum in sentencing jurisprudence. And we go over various examples of where there's a lack of reasoning by the courts and inconsistency. The ICTY, the ICTR, the Yugoslavia and Rwanda tribunals were better. They did establish principles of proportionality and consistency. They did refer to concepts like deterrence, retribution, and rehabilitation. But the jurisprudence was still limited in scope. It was inconsistent across tribunals and chambers, and once again, lacked needed coherence. Later tribunals, such as the Special Court for Sierra Leone and the extraordinary chambers in the courts of Cambodia, exhibited similar tendencies. We go into greater detail on that in the paper. And then that brings us to the ICC. So to put into context where the ICC could be, or how it could be punishing ecocide, we have to look at the key provisions in the Rome Statute. Rome Statute Article 77 authorizes custodial sentences, whether, first of all, for a specified number of years, not in excess of 30 years, or for life, though the court is only empowered to impose the latter penalty, quote, when justified by the extreme gravity of the crime and the individual circumstances of the convicted person. Fines and forfeiture are also permitted. I do find it odd, and this is a parenthetical, that there is 1 to 30 and then life. I do think that there's room for gradation beyond 30. I just want to put that out there. But we get further clarification from Article 78.1, which refers to the rules of procedure and evidence, Rule 145, that the sentence should reflect culpability based on, first, mitigating aggravating factors, second, circumstances of the defendant and the crime, third, harm caused to the victims and their families, fourth, the nature of the unlawful behavior and the means employed to execute the crime, and fifth, the degree of participation of the convicted person, finally sixth, the degree of intent. And we just heard some very interesting talk about mens rea, so very helpful. But the ICC case law on sentencing to date makes clear that of all these criteria, measuring the crime's gravity is perhaps of greatest importance. There's some very interesting commentary from the court in the Oldring case, and where the court talks about assessing gravity both in abstracto and in concreto, and I promised that I would talk about that, so let me do that. In abstracto gravity has to do with the general nature of the crime itself. It's more of an abstract concept. And while uniform across all ICC ecocide sentencing scenarios, in our paper, we submit that there are certain analytic factors that would be very important to focus on. First would be traditional penological justifications for punishment, and I'll go over those with you. Second, ecocentric versus anthropocentric perspectives on punishment. Then we think it would behoove the international community to look at punishment through the lens of Foucault's philosophy. And then finally, ecocide's relationship to the ICC's other core crimes. Let's unpack that. First, those traditional penological justifications. When I teach criminal law, I always focus primarily on retributivism and utilitarianism. Retributivism posits that punishment is justified by notions of just deserts, payback, and moral debt. Tends to be backward-looking as opposed to forward-looking. And I'll talk about that with respect to utilitarianism in a moment. But ecocide-focused retributivism suggests a relatively high level of gravity because the natural environment, its most direct victim, is particularly vulnerable. But it's also harmful to natural persons, both in terms of health and habitat destruction, as we've heard, especially from Lisa. Utilitarianism looks forward. So it has kind of an opposite directional focus, seeking to prevent future such conduct via incapacitation. And given the IEP's severe and either widespread or long-term damage part of the definition, this, I think, necessarily implicates, and we heard about this, I think, a lot with respect to the oil sands, heavy, complex regulatory restraints, serious rehabilitation, which is very resource intensive, cleanup, restoration, and deterrence, which I have to say we should finally start considering incarceration for individuals who are responsible. Some other important justifications I say would include expressivism, which serves to communicate moral disapproval, condemnation of the wrongdoing, and punishing ecocide. I submit voices the global community's sense of moral outrage for crimes like Bhopal, like ExxonMobil. So, restorative justice, which of course dovetails with rehabilitation. For example, replanting damaged forests, restoring wetlands, species reintroduction, long-term monitoring, and healthcare. But also, it would seek perpetrator-victim reconciliation. For example, promises of non-repetition, efforts to restore and respect indigenous sacred lands, which we've heard about, customs as well, and creating monuments, education centers, just among the many examples. I also mentioned that it would be helpful to look at punishment through the lens of ecocentric versus anthropocentric perspectives on gravity. And so another type of in abstracto analysis could be from the perspective of environment as victim, which would be ecocentric, or victim, person as victim, in other words, anthropocentric. We've heard a lot about that today, but I'd say that in terms of the way that environmental crimes have been perceived to date, we've largely been looking at an anthropocentric bias. In other words, concerns with human aesthetic, cultural, and or economic problems. But I hope, and I think from today's discussions, that an ecocentric account is trending. There are questions that it raises, though. It could be hard to measure. I just give this as an example. This is in the paper. Should we look at individual trees? For example, we could look at a tree that is millennia old, or should we look at the entire rainforest? What's our measure? Very difficult questions that get raised. I mentioned Foucault, and in his seminal 1975 treatise, Discipline and Punishment, or Discipline and Punish, The Birth of the Prison, he charts the historical evolution of punishment from its earlier use as a corporal pain-oriented mechanism into a more regulatory-focused system of social management via prisons. He calls this disciplinary power, and he sees it as a necessary component of organizing large, complex institutions like schools, armies, hospitals in modern societies. It's somewhat like systems theory. It's not punishment in the traditional sense, but sentencing ecocide perpetrators, I would submit, entails something similar: complex, involved remediation efforts, such as restoring habitats, cleaning up toxins, and reintegrating animal and human populations, and instituting future legal restraints. And that really, I think, meshes well with Foucault's disciplinary power-flavored notion of punishment. I also mentioned comparing to the existing core crimes. Although aggression has been dubbed the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole, and one of genocide's monikers is the crime of crimes, because it is thought to carry the highest moral opprobrium, there is an argument, I believe, that ecocide is even more heinous than these. The existing ICC core crimes deal strictly with natural persons as victims, except, of course, for aggression, which also encompasses sovereignty. However, ecocide involves more than one victim class. It covers two: natural persons, whose ecosystems and often livelihoods or lives are destroyed, and the environment itself, a more vulnerable victim, I would submit, than a nation state, which is the focus of aggression's sovereignty violations. Unlike the other core crimes, ecocide could also include, as we've heard today, intergenerational macro geographic harm. You're talking about harm that could spread through the air across the entire planet. Finally, in concreto, gravity. We should be looking at things like the potential enumerated acts, killing, harming, or removing protected flora or fauna, for example, destroying or damaging ecosystems or wild animal habitats, trafficking or dumping hazardous substances. The role in the offense will be important. I think from the Colombia example, we heard some aspects of that. Are we talking about a leader or subordinate? That's fairly straightforward. But what about a military commander destroying wetlands because he knows that they help conceal rebel forces? Is he more culpable than a corporate executive who contaminates a similar ecosystem for profit motives? Those are difficult questions. And then aggravating or mitigating circumstances. A history of dumping toxic chemicals into waterways obviously would be a type of aggravating circumstance versus protecting natural persons by destroying an ecosystem to protect them from attack if the destruction had not impeded the perpetrators. You look at certain crimes like Russia's 2023 destruction of Ukraine's Kakhovka hydroelectric dam, which could qualify as genocide, crimes against humanity, or war crimes. You look at Saddam Hussein's destruction of the Kuwaiti oil fields. All those could also qualify as ecocide. But what was the main target of that crime? Was it economic activity? Was it human life? Or was it both? Some of the other speakers have raised very important questions that will need to be answered, and this is certainly true in the punishment context as well. My concluding thoughts are that, and I see I've got 14 minutes on my stopwatch, so I'm going to hit 15 exactly, analyzing possible punishment outcomes in respect of the IEP ecocide definition, we believe, reveals much about the proposed crime's basic nature. And that's why, even at this early stage, we believe it's important to focus on punishment now so that we can better understand liability. But I also think that it raises the question of whether the IEP definition is not the ideal formulation. It seems to be a conduct-oriented offense, in other words, perpetration of certain conduct with a certain mens rea, but no specific result. But what kind of conduct are we talking about? Would it be helpful to have enumerated offenses or enumerated acts? And if so, would we be better off calling it crimes against the environment instead? I think this is something that Matt's dealt with in his scholarship. So I think these are questions that we have to keep in mind as we think about the liability parameters of ecocide, because punishing ecocide is very important, and I hope it gives us a basis for further discussion. Thank you.
And totally valid point about considering punishment or sentencing at this stage, because with HEP, I know it's also been like a kind of like a learning experience, right? And trial and error type of thing when, you know, you actually have to punish or think about punishment. So please tell us a little bit more about that. I know we're a little bit short on time, but please do your thing.
Well, very briefly, in terms of the Colombian experience, the special jurisdiction for peace builds on the recognition of nature as a subject of rights that happen in Colombia, and it has happened like in other jurisdictions, like in Ecuador or New Zealand, I believe. So in Colombia, the Constitutional Court in 2016 recognized the Atrato River as a subject of rights. In 2018, the Supreme Court of Justice recognized the Amazon as a subject of rights. So that opened like a space for opportunity. And building on that, the Special Jurisdiction for Peace recognized as a victim of the armed conflict, recognized two rivers, the Cauca and the Magdalena, and also recognized traditional territories of indigenous and Afro-Colombian communities. So that's one point, and also that brings challenges as well, because first of all, like how is the participation of this victim, you know, who represents the interest of this victim, you know, that's like one question, for example. In terms of sanctions, also they try to go forward and not just strictly to ecological restoration, but also cultural healing, taking into consideration the indigenous and Afro-Colombian epistemology. They open like that space, so there is this healing with the cultural practices that were impacted by the actions of in this case of the military actions of the guerrilla. So that was also taken into consideration, and they are actually implementing. They are starting to implement some strategies for repair and restoration, both environmentally and culturally, but with many challenges. It's not easy. But they are trying some pilot projects of this. One is a project called Harmonizing the Territory for the Awa indigenous people. And yeah, there are already some complaints like about the coordination of the different institutions for this and the lack of funding. Also, another complaint that is already arising is like the tension between judicial formalism versus community-based repair. So that's also like a question that it's open there. But yeah, I think this experience of the special jurisdiction for peace shows like some possibilities and also the limitations that you might face on doing this. But also very important is that it's not only like a punitive, but it needs to go to the transformative restoration. I'm using the experience of the special jurisdiction for peace in Colombia.
PAPA is really pioneering in this aspect as well, right? And thank you all so much for being so respectful of your allocated time. We now have about 22 minutes for Q&A, so I really want to open up this space and take questions. I will take one by one because I feel like it's easier to track, but please keep your questions concise so we can have more. Yes, John?
I have a brief question about the mens rea element, and I believe it was on your slide. I was just wondering if you could touch more about the nature of bridging the gap where recklessness might necessarily create an incentive for companies not to do certain research or not to do certain investigations as to avoid the certain culpability that comes with the knowledge. How do you see countries or international courts bridging that gap?
Should we take different questions?
Yeah, go.
Yeah, so this was briefly mentioned in my slide. So the counter-argument to recklessness, right, like the downside of that criteria would be, well, compared to negligence, especially if someone fails to acquire knowledge that a prohibited result would follow from their actions, well, they're not aware of a substantial likelihood. They're just not aware of everything. So that's great. So that's a counter-argument that arguably these people would evade responsibility with recklessness. Well, thank you for the question because it allows me to address that as well. I think in several cases, for example, the tar sand is such a great example as well. I don't necessarily think that it would allow them to escape responsibility. For example, in the context of a tar sand extraction, if has been ongoing since the 1960s, at this point, even if a company was like to not conduct any environmental impact assessment, let's say we take a very extreme case, it's still quite difficult to argue that they're not aware of a substantial likelihood at this point. So that's another argument in my view to argue that recklessness still like doesn't make it that easy to completely escape responsibility if you really keep your eyes completely shut. Yeah.
Okay, we can take another question. Yes, gentleman in the back. Please introduce yourself before your question.
My name is Mark Alderson from Crawley CO2 Matters. What I'd like to ask is a proposition being put forward by Steve Keed when he's talking about economists relating nature data to economic data. And his argument is that the metrics that are being used to correlate nature data to economic data is flawed, and there will come a tipping point when people realise that the effect of nature on economic factors has been underestimated. And then suddenly we will realise that nature data have a much greater effect on economic factors than we thought it did. And I was wondering whether that would eventually feed into sort of the sort of concept of punishment for people who commit ecocide?
Yeah. I think that the science is going to evolve, and I think we have to, I mean, punishment is going to be reflective to some extent of how we measure damage. And if we're trying to strike that balance between anthropocentric and ecocentric views of punishment, we definitely need to understand better the relationship between nature and habitat destruction, for example, and damage to the environment versus economic consequences. I think that's evolving, and I think we're going to understand it better over time. I think the question is, do we have enough time left? I mean, I think that's the question that is hovering over everything that we've talked about today, is that we're running out of time. And I'm encouraged that the science is getting better, but I'm discouraged that humanity is not understanding how incredibly grave all of this is. So yes, we need to keep moving in that direction, but I think the things that we're talking about today in terms of normative change and perceptions of what we're doing to the planet have got to go faster and not be linked just to science. So I just want to make that point.
We can take another question. Yes?
Yeah, thanks so much for these great presentations. My question is primarily to Lisa. I work at an organization called Forensic Architecture. We do spatial analysis in human rights cases. But we've also been working, or I've been working on cases of environmental violence and mining in Canada as well. And in that case, it's the case of green colonialism, where there's like an excuse of the need of precious minerals and that being a reason to override indigenous jurisdiction. I'm wondering about how you talked about the use of climate obligations as a defense. And I'm wondering about, from a strategic perspective, the risk of using climate obligations and similar kind of questions about like emissions as a pretext, or kind of opening up a pretext of green colonialism or extractivism elsewhere in Canada or internationally by Canada. And kind of the question is, how do we avoid simultaneously a single incursion and the cantonization or division of communities in Canada, or it's kind of an international struggle against environmental violence.
Can you just repeat the last part of the question?
I mean, how do we work to defend communities in places like the tar sands while avoiding the division or the separation or isolation of cases in international or environmental justice work?
Try to fully grasp the last part, because there's within the area covered by the oil sands, there's a diversity of indigenous communities and voices, and some have argued, if you look at the literature coming from the companies operating there, they will highlight where indigenous communities have signed benefit agreements, and they are very much in favor of and working together with companies. And there's, I don't think it's an explicit intention, but there's certainly a separation from other, sometimes the same communities or other communities that are very much forcefully speaking out against the harm being done in those communities. And I don't think it's an either or. I think it's, look at the voices that are talking about the harm. The harm is the point. The harm is what we're looking at when it comes to assessing whether the, sort of overarching harm that's being damaged, that's being done, amounts to a crime. So I don't think there is a risk in that sense of separating. I don't know if that goes to what you're talking about at a more kind of global level. I think the first part of your question is a really interesting one, looking at what is being said by international courts related to climate change obligations that governments have and how that might be interpreted for example, in Canada, we don't yet know how much weight the opinion will be given to courts in Canada. But I think that is going to start to really change as courts start to interpret what the International Court of Justice and the Inter-American Court and other courts have been saying about climate change obligations and the fact that these include the full body of law. They don't just include the Paris Agreement, they include obligations under human rights law, obligations under international environmental law, and so on. So I think in the Canadian context, we have one case, Catherine can help me better, where there's at least a nod towards integrating the ICJ advisory opinion and giving some weight to that opinion.
Yeah, it's from the federal court last month. It's Dijkstra case, D-Y-K-S-T-R-A. So there's a nod to the advisory opinion, and basically the claim will be able to move forward. It's progressing. So for now, it's just a nod, but it's great to see it being referenced.
Yeah.
Question? I don't see any hands.
I have a question. If that I had. The question about mens rea. Were you looking, when you were looking at indirect intent, were you looking at it from sort of the British or English oblique intent standard?
So, yeah, that's a great question as well, because all of these different standards that I referenced, like recklessness, negligence, or direct intent, or dolus eventualis, they can have different meanings, different shades, let's say, in different domestic jurisdictions as well. So already defining all of these contexts in the context of all of these terms, in the context of the Rome Statute is already was a challenge in the paper as well, and sometimes international criminal law is not necessarily clear as to what it means when it says, like, when it uses dolus eventualis or recklessness, or so there is some an uneasiness there in international criminal law. But indirect intent has been sometimes equated to oblique intent also in certain cases in international criminal law. Yeah.
Because I was going to say that there is a standard under American law from the Model Penal Code, which is practically certain, not virtually certain.
Yes. So yeah.
And I was wondering if you consider that in the paper or.
So yeah. So in the case law of international, the ICC and the Alberta tribunal, sometimes you see virtually certain, sometimes you see practically certain as well.
Right.
So I think in ICL at least they are used interchangeably, virtually certain, practically certain. But that's
I mean, I think practically certain is a little less stringent, if we could just put it out there. But it's close. I hear you. The other thing I want to ask you is you said that direct intent was almost irrelevant with respect to ecocide. But I was wondering in cases like I mentioned Iraq's invasion of Kuwait in 1990 and the destruction of the oil fields, that to me looked very much like direct intent, or even the dam example that I gave on Russia. I do think it's there, and I wanted to get your reaction on that because
yeah. No, thank you for the question. I think that's something I discussed in the paper as well. So I really try, and also that's also with the interest of time, but thank you for the question to expand on that. So I really tried to identify cases that would fall under direct intent in the context of ecocide. And so the example that I identified that resembles the one you mentioned as well would be the U.S. action in the context of the Vietnam War. Right?
I was going to say dropping napalm in the jungles of Vietnam was one that was on my mind too.
Yeah.
Yep.
If the foliation is the aim to facilitate military maneuvers. So, but then the issue that I find is that I wasn't able to find an example that happened outside of the context of armed conflict, which is quite a significant limitation.
Can I say something here? Because I think this is true for this entire conference so far, is that it seems like there's a basic divide between corporate criminal responsibility and responsibility for things related to aggression or war crimes, or even crimes against humanity. I don't know whether the two are, if they live, if you will, in separate realms of the law in such a way that we have to consider a carve-out or something. I don't know. And of course, we know we have Additional Protocol 1, which we haven't really talked about, which is sort of hovering out there. We have the NMOD treaty. There's a lot of, I think, kind of hardcore criminal, where you're going to have more direct intent or even indirect intent, as you point out.
Yeah, and even in the Rome Statute, like we have A2B4, so like war crime of environmental destruction in the context of international conflict.
Which comes from Protocol 1.
Yeah, exactly. So I think if we are to add ecocide in the Rome Statute, I think we don't want to repeat what is already there and A2B4 being in the context of armed conflict. So in my view, the interest of adding ecocide in the Rome Statute lies, at least in part, in criminalizing environmental damage in peacetime as well. So that's also why I feel I'm not very convinced by direct intent, because if it is to happen in the context of armed conflict, we already have it to before. So
yeah, but wouldn't you admit that that section, that provision, is extremely restrictive? It has a very high standard. This seems to, if you will, ameliorate that problem a little bit. And so I don't know that I would feel comfortable simply saying, oh, well, that's siloed off in Article 8 to B4, and then this is just for commercial enterprises. I'm a little, and I think that's a significant underlying question in what we're talking about today. That's why I wanted to bring it up.
No, it's true that A to B4 is quite narrow as well. It includes indirect intent, that's it, so it's even lower than direct intent, but still, like, for limit, it's still quite stringent, but it is still limited to international armed conflict, I think. So
as well,
I think, I mean,
you could not have an IAC or a NIAC that qualifies, right? And yet you could have a military, or you could have a non-organized armed group engaging in this kind of activity, and there's something that's missing. This potentially gives us the ability to prosecute crimes that don't fit within that. But I just think we need to make sure that we're okay on the mens rea with that, and that's why.
No, I think we can have different discussions. If ecocide was meant to be applied only in the context of armed conflict, I think we would have a different discussion about mens rea. But nowadays, I think the dominant understanding of ecocide when we talk about it here is that it's meant to apply also in peacetime. And whether that should be a separate offense, I think is another discussion.
Or if the chapeau doesn't apply, which is possible too.
Yeah.
It's a stopgap.
That's very interesting. More questions? We can take one more.
Oh, are we at the end?
Surely for you, Kate.
You have special dispensation.
I wanted to ask Hector actually to take advantage of you being here and to ask what the conversation is, if at all, in Colombia about criminalising ecocide, especially in the light of all of the developments you've described, but also the rights of nature and so on. Is there a conversation about introducing the crime?
Yeah, there is, and that was also connected with the conversation that was here. The Colombian Criminal Code recently included the ecocide in the context of armed conflict in the criminal code. However, all this, like the special jurisdiction for peace, only covers from until 2016, because it's part of the peace agreement. Otherwise, it goes. They say like we judge only actions between 2016 until 1980s. So this doesn't. This is not included. But yeah, that was included in the criminal code. It's pretty much an open debate there. But also then it's connected with this conversation of like, and they were checking the Geneva protocols, and then it's like it's for international armed conflict, and in Colombia we don't have an international armed conflict.
NIAC.
So then they started like, then they used the TADIC test from the tribunal in Yugoslavia, trying to to be able to apply this the Geneva protocol into internal armed conflict. So there are things to be done there.
Just to be clear, A2B4 only applies to international armed conflicts, so it's limited. It doesn't cover non-international armed conflicts, which is Colombia and so many other conflicts around the world. Yeah.
I was told that we were supposed to finish at 2:45. But I'm sure conversations will continue after this panel beyond. This has been a very thought-provoking discussion. Thanks to all our panelists. So we've examined the definition of ecocide both in theory and in practice. And I think one of my takeaways is as legal professionals, we're not only just watching the legal space, but also how it interacts with scientific developments, social, cultural, economic developments, right? So I think it is also upon us to be informed, at least, of what's happening outside the legal, nerdy world. So yeah, and to do so with some urgency in mind, as Gregory has said. So, but thank you all for your attention. Thanks again to our panelists. I think we're due a break, but we'll be back a bit. So.